The alleged intruder, Bongani Ntanzi, wraps up his evidence in chief, now opening up for his version to be put to the test. Hello and welcome to Inside the Courtroom, the Senzo Meyiwa Murder Trial rep. I'm Linda Mnisi. It's an absolute pleasure having you with us this Sunday afternoon. So, as you know, and now that Bongani Ntanzi has concluded his evidence in chief, we have our poll question for you. And what we're asking you is, do you think that Bongani Ntanzi has, of course, set himself to, of course, collapse the state's case, or is worse off and also waiting for his witnesses? You're actually waiting for his witnesses. So that QR code is on the screen. You can vote by scanning it and then, of course, making your voice heard. But you can also tweet us on social media platform X, that is at Newzroom405, but also you can send us your message via our Facebook page. We'll make sure to read all of them at this particular point and throughout the show. This poll will be running. But also, you know, to unpack all of this evidence, we also have our panel of guests who will be joining us shortly. All right, as you know, regularly we do have our studio guests who will be joined at a later stage by Bongani Masuku. You'd know Masuku is one of the people who are social commentators. They're following this particular case regularly, but also we do have commentators as well. Another commentator, in fact, that's Itu Mokwena, joining us for the very first time. She's joining us via our video link, but also our legal analysts who help us make sense of everything as we discuss it and go through the evidence, Kabelo Siabi, as well as Bongani Masuku, who will be joining us shortly. Let's go to Kabelo Siabi. Kabelo, thank you very much for joining us. I want us to start by taking a look at Bongani Ntanzi's case. I mean, he at this point has wrapped up his evidence in chief. When you look at it holistically, right, because he's yet to be cross-examined by the state, but also, you know, he is, is done with his evidence in chief and leading his evidence. What do you make of all of it?
Good afternoon, Linda. The evidence that has been given by Mr. Ntanzi, obviously it is in response to the case that has been made out by the prosecution against him. You will remember that in the prosecution case, he is placed on the scene by being placed at Basotho Hostel, and there are various pieces of evidence that place him at the vicinity of the offense where the crime took place. Now, he must place evidence before the court in order to have the court assess between the case that has been made by the prosecution and his version as to whether the state has proven the case against him beyond reasonable doubt. I must qualify by stating that you must remember that it is the prosecution that carries the burden of proof in a criminal case. An accused does not have a burden of proof. The accused must simply give a reasonably, possibly true version, and even accused gives a reasonably, possibly true version, they will be entitled to an acquittal. Now, what Mr. Ntanzi has been saying is that he was not in the vicinity of the crime scene and has raised what amounts to an alibi, that he was at a different place than where the offense took place. Therefore, it will be incumbent on Mr. Ntanzi to place evidence that the court can accept, which will say that he was not at the vicinity of Basotho Hostel, nor at the Khumalo home where the crime occurred.
Yeah, and because we're talking about his evidence holistically, right? His evidence in chief in particular, do you think he's sort of laid the foundation for what's to come? I mean, we know what the state alleges. He is the alleged intruder who was wearing a hoodie. We have people that have identified him, as you have just rightfully pointed out. But do we know exactly whether or not he has laid a foundation, a strong foundation, that is, in response and in rebuttal of the state's case?
Look, I must tread carefully in a sense that I am not allowed to say or to second guess what the judge is going to decide with regard to the evidence that has been given in court. Because of the reason that the authority of the court must be respected, one is not allowed to say that the version of any witness is not to be believed, or the version of a witness is to be believed prior to the court pronouncing on that aspect. What I can say is that the evidence that Mr. Ntanzi has led on an overall, it will have its own challenges, in a sense that his evidence is a bare denial of being there, when there is evidence, direct evidence, that places him on the scene, and there is direct evidence that he was at the place where the offense took place.
Yeah, and I want us to take a look at, the evidence around his disputed lawyer, Ntokozo Mjiako, because that particular evidence is something that he went through extensively, right? And, he also talking about how he never gave him a mandate. But we know that it's really not the first time that he's dealt with the issue of Ntokozo Mjiako. And for those who don't know, Ntokozo Mjiako is a lawyer that was allegedly present when he deposed his second confession statement, where he incriminates or allegedly incriminates himself as the second intruder into the house. And in that particular room, there was Magistrate Vivian Cronje, there was a court interpreter, as well as Ntanzi and this disputed lawyer. I want us to go back to October 2023, during the cross-examination of the magistrate Vivian Cronje by the late Thulani Mngomezulu, who was the then lawyer of Bongani Ntanzi.
Other than a confirmation by the interpreter, there's nothing that you can confirm that Mr. Mjiako was present on that particular day.
Your client can confirm that.
Instruction that he was not represented on that day, and he does not even know Mr. Mjiako. It's my instruction. That's why I'm still insisting on the right to legal representation.
As dit u instruksie is, dan vertel u kliënt nie vir u die waarheid nie.
If that is your instruction, then your client is not telling you the truth.
All right, so that was in October 2023, Kabelo. And we know that it seems, I mean, looking at that bite and what Mngomezulu was saying at that point, it seemed as though he was essentially saying Muzi, or in fact, Bongani Ntanzi was not represented, Ntokozo Mjiako was not there, because according to his line of questioning, there's no other proof that Ntokozo Mjiako was there. You juxtapose that now with what he's telling the court about him not being represented, and you also look at the evidence around the court appearances where he's seen on record as the lawyer on record representing Ntanzi in another unrelated matter. When you look at his fight against this disputed lawyer, what do you make of it?
Linda, this is what I alluded to earlier when I said the evidence of Mr. Ntanzi will have serious challenges, You must remember when the court approaches the evaluation of evidence, the court applies what we call probabilities. It makes a probability finding as to what is most likely to have happened. Now, on a balance of probabilities, the following issues will come to the fore. Why would Mr. Mujiako have left his place of work or office? And why would he have been present in the room where the confession was taking place if he had not received any instruction? Why did Mr. Ntanzi not raise any protestation to the magistrate when the magistrate was engaging with Mr. Mujiako in that office? And very strangely, Mr. Mujiako then appears on record at the magistrate court on his behalf, representing him. Again, he does not raise any issue that I do not know this person. So if you apply probabilities, his evidence is going to be problematic in that sense.
Yeah, and I remember with our panel of guests last week, we also discussed, amongst others, the termination of a mandate. He does confirm that he terminated the mandate. And I remember one of the questions I asked was, how do you terminate a mandate that you did not give?
Obviously, when a client comes to you, they have to instruct you. They have got to give you a version. They have to tell you what it is that you need to do on their behalf. And that is what would constitute a mandate. And if the client at any stage feels that they do not want to progress with your services, they want to instruct a different legal representative or legal practitioner, then the client will then terminate or end the instructions that you were given and give those instructions to a different person.
The confession statements are quite crucial, right? Because some argue that it has the potential of bringing the state's case against Bongani Ntanzi to its knees. Now, what are the most critical elements to do that at this point? And looking at his version and his testimony, do you think there has been at least any attempt to sort of do that?
Linda, the confession, you will remember that there was a trial within a trial, and there was a ruling at the end of the trial within a trial. The ruling at the end of the trial within a trial was that the court ruled that the confession could be utilized as evidence, meaning that it is admissible. It will be admitted into evidence in the trial. Now that ruling stands, and that ruling can only be overturned if during the rest of the trial there is persuasive evidence that the ruling that the court made in the trial within a trial is incorrect. And at this stage, I have not heard anything that I personally would see as a basis of a persuasive nature to say that the ruling that the court has made has been demonstrated to be incorrect.
All right, I want us to take a quick ad break, and we'll discuss or have this discussion when we return. Stay tuned. Sibongiseni, hi, can you hear me?
Yeah, I can hear you.
Okay. Bongani, can you hear me? Bongani, hello, can you hear me? Welcome back and thank you for choosing to stay with us. Now, Bongani Ntanzi, that's accused number 2, also testified about how he knows his co-accused. He told the court that he only knows accused number 1, that's Muzisibia, the alleged lookout man, who the state believes kept watch during the murder of the footballer. But he says he met the rest of his co-accused when they made their first court appearance at the Boksburg Magistrates Court. That's on the 27th of October 2020. Of course, the state alleges that accused number 5, Fisoguhle Ntuli, was the alleged coordinator of this alleged hit who communicated allegedly with the accused. This is the man that the state alleges communicated with the alleged mastermind as well. That's Kelly Kumalo, on 2 occasions before the death of Senzo Meyiwa. The state and defense are also at loggerheads about a number that is said to have communicated with the accused. So could it be that a man known as Lungisani, or could it be Fisoguhle Ntuli? Let's take a look.
Colonel House has testified that the investigating team, that it will be Sergeant Mohola, Gininda, Mabena, Mohani, whoever was participating in this team to investigate, identified this number, the 071 595 1239 number, as that belonging to Fisoguhle Ntuli, who is accused number 5 in this court.
That's not true, my lord. I don't know Ntuli. I don't even have his number because I'm the one who raised my hand and brought it to my legal representative's attention to rectify that this was not Ntuli's number, but Lungisani's number.
And have you made a call to the 1239 number at any time since you've had it communicating and it was answered by someone called Fisoguhle Ntuli?
No.
All right, I'm still joined by my panel of guests, and as I mentioned earlier, I have Bongani Masuku as well as Itu Mukwena, who are both commentators. Itu believes the accused in the dock are the right persons who killed Senzo Meyiwa, while Bongani Masuku, as you may know by now, believes that these are not the guys. The state has the wrong people here. To help us understand, I also have Kabelo Siabi as well as Bongiseni Gunene, who are our legal analysts. Let me come to you, Itu. I want to get a sense of what your impressions were with Bongani Ntanzi's evidence in chief. I know you reflect daily on, the case and what actually comes out. So are you convinced that he may have cast doubt against, or rather against the state's case against him, rather?
I'm back, I'm back. Thank you so much, Linda, for the opportunity, and thank you for the listeners at home. I absolutely do not think that Mr. Ntanzi and Ramsipila were able to cast any doubt on the case, on the state's case. I had a high expectation on his evidence in chief, but I feel that you cannot just dismiss or rebut evidence, especially the type of evidence that the state has. You cannot just rebut that evidence with just denial. You're just denying and you're giving us different versions that will be compared. What you have said in a trial within a trial, or everything that you have put to the judge during any other witness that had been there to testify against Ntanzi, will be put against what he is now saying. So I am not convinced, not even a little bit. This guy's in trouble when you see.
Yeah, and I want to come to you, Bongani. I mean, you've heard what Itu has to say. What are your thoughts?
I told you that we are cooking. The cooking was not done when I last spoke to you, right? So you now can see where everything is going. Attorney Ramsipile already confirmed that we will be bringing more witnesses. But I want to highlight some of the things there on. Number one, we'll start with the number, the Lungsan, which the number that Ntanzi started using in 2018. That number, it's the one that starts with 060. He started using that number in 2018, but the state made it look like he started using that number in 2014. Number two, it's the number that starts with 071 that is said to be belonging to Ntanzi. The number that he's disputing, saying that according to Mshololo, that number actually did not contact accused number, or there was never a communication between accused number 2 and accused number 5, because also they did not know each other. Then you bring the issue of Ulungsan. I've known personally for quite some time that the number that is said to be belonging to other people, actually the owner of that number is still alive. And if I'm not mistaken, that guy works in a construction company, or if he does not own that construction company. So you will have to tell me, just that alone, you'll have to tell me, how did we arrive at a point where we using certain information and portray it as if it belongs to somebody else, when in actual fact that information doesn't belong to that person? I told you we're still cooking, and I'm telling you now we're still cooking.
Yeah, Sibongiseni, you've heard Bongani, and in relation to the number, the disputed number, who does it belong to? Lungisani Ndwandwe or accused number 5, Fisoguhle Ntuli? Do you think it's clear from the state side who this number belongs to? Because most recently we heard from the prosecutors around who they believe it belongs to, either Lungisani or accused number 5. And why is this important?
Good afternoon, Linda, and the guest, as well as my learned friend there and the viewers at home. This number which we are talking about, there is a problem about it, and in fact, it has to be put correctly so, because when I remember very well, Advocate Mshololo objected when that number was read and said they are intending to call that said person who is the owner of the number, right? Well, there is an expert which was called by the state, and being a host and Stein as well, who testified about how they link the number to accused number 5, right? Even though then there is no clear indication as to whether by the fact that this number at some point was given by accused number 5, or at the time when maybe was found in contravention of the Road Trafficking Act by the police, and he happened to give this number. But it is common cause that at some point a human being can give a number which he or she is reachable at that given time, if then there is no any other number that he has. But nonetheless, it does not suggest that the number belongs to accused number 5. So we only know that when you want to confirm a number that belongs to a certain individual, RICA is important. But in this case, we didn't have any RICA information suggesting that the number that which was alleged to be Lungsani belongs to Lungsani or accused number 5. Nonetheless, they are electing just to bring other information or evidence that suggests that circumstantially, so we can then link this number to accused number 5. Well, we had the version which was put by Advocate Mshololo. I think Lungsani Ndwandwe might be a relative to accused number 5. So there is a possibility that at some point accused number 5 gave this number of his relative. But until then, Lungsani, who then is alleged to be the owner of the number, come to court and rebut such evidence. Then we have to believe the evidence of Lungsani at that point. Even though there is an expert that has come to testify about this, but they've never mentioned any RICA information insofar as the number is concerned. If there was RICA information, maybe we would have a different approach about the number, but now maybe we'll rely on the probabilities or the relevance of the evidence that will be given by Lungsane if he comes to court. But then if Lungsane does not come to court, then accused number 5 will have the problem about that number. But now we are waiting for Lungsane that is going to come to court.
Yeah, and if we are to believe Lungisane's version, what does that mean for the state and the allegations of there being communication amongst the accused, the doctrine of common purpose, because obviously the state is alleging that accused number 5 is the alleged coordinator who brought them together. So if Lungisane is to be believed, then what does it mean for the link? It's not the only link that the state, by the way, wants to establish between the accused as well as accused number 5 and the alleged mastermind.
Well, if you want to talk about the linkages amongst the accused, there will be a likelihood that you can link this accused to accused number 5 through to this, because if Lungsane is a relative to accused number 5 in proximity, maybe can you easily infer that there is a possibility that Ntanzi, who alleges that he does not know accused number 5, maybe there will be a likelihood. And if so, is it strong to believe that indeed there is a likelihood that he knows accused number 5 based on that piece of evidence? Unfortunately, then, when you look at evidence, you look at it holistically, so right in its totality. So it's not only this evidence that could be used to prove the linkages. So if then there's another evidence that is supporting this number of Lungsane and the notion that has been brought by the state to say, accused number 5, then will be strongly be built, because this one will be contributing to other pieces of evidence if it's there.
Yeah, Itu, I want to come back to you because I want us to talk about the issue of the pictures that were found in accused number 2's phone, Bongani Ntanzi's phone, as well as how that links to perhaps the descriptions that were given. But we also know that the cell phone evidence also goes as far as alleged communication at the time when Ntanzi is said to have been in prison, pictures that were allegedly taken at a time when he was supposed to be in prison. Talk to us about what you make of the cell phone evidence around description, but also whether or not Bongani Ntanzi could have had his phone at the time when he was in prison.
Thanks, Minisi. If we look at the evidence that has been laid in court, for me, it's quite clear that Ntanzi had his phone. If you look at the contacts that were reached out to during the time he was in prison, his then girlfriend was contacted over, I don't know how many thousands of times the girlfriend was contacted. We all know that Mujiako also got a please call me, not a call, because a call you can easily say, I sat on my phone and then it dialed the number, I randomly dialed the number, but a please call me, he went and he's dialed *140, Mujiako's number, and they spoke. They didn't speak for 1 minute, they spoke over 5 minutes, 15 minutes, So for me, it is quite clear that Ntanzi's phone was with Ntanzi at the time. Now, when it comes to the picture evidence that was laid, I don't know what Mr. Ramsipila was trying to do when he was leading the photo evidence, because he was going around the description, because at some point Rata said, but can you see an oval beer shaped on these pictures? Yes, these were pictures that were taken prior the incident, but can you see those things there? And they were quite obvious. He had an O-shaped beer, he is tall. These things are linked to him. He has been described by the people who were in the house, people who were not in the house, and people who said that they saw him before he went to the incident. So he had a lot to answer to. And for me, just giving denial as an explanation as to how are you being linked in so many ways with this evidence, just for you to deny it was not enough. He is going to face problems.
Yeah, so the conclusion of Bongani Ntanzi's evidence in chief saw Advocate Charles Mnisi start his cross-examination, and among some of the issues he picked up on, and is the description, rather, of Bongani Ntanzi given by a witness who has since passed on, and that is Thabang Makeleni. It just touching on the issue around his description. This is another witness who gave a statement but has since passed on. And I want us to take a look at that cross-examination, all those questions from Advocate Mnisi regarding that particular statement. Take a look.
And I think this is evidence that will be dealt with later on when other witnesses are coming for the defense. Do you understand?
Ngicabanga ukuthi lokhu ke ubufakazi ke esisezoqhubeka ngabo uma ngabe beseza ke abanye ofakazi.
Now I think this was Mr. Makaleni. Mr. Makaleni was residing at 3942 at Muzamo. He hasn't testified. He hasn't testified on behalf of the state, but he was approached by the state when the state was investigating this case. And this is what he gave of, this is what he said of the second suspect. He said he saw suspect B at the gate and gave the following description: plus minus 25 years old.
Indlela ke amsho ngayo amchaza ngayo ukuthi ke umsolo wesibili wambona egate ukuthi ke wayengaba phakathi kweminyaka ewu25,
1.8 meters tall,
ukuba bude ke wayengaba 1.8 mameter,
slender build,
nomzimba omncane,
a golden inside in the upper teeth,
nezinyo legolide la ngaphezulu.
In brackets is written not sure where.
Washo ukuthi engenaso kodwa isiqinisekiso sokuthi kuphi nendawo.
Dreadlocks hairstyle,
nama dreadlocks,
facial hair,
nokuthi ke nalana ke ebusweni ke enoboya ke nenwele,
mustache and beard.
Kanye futhi ke enayo ke nentshebe.
Then this witness went on to say that he saw something in his hand that he and then he says he's not sure whether it was a firearm.
Washo ke ukuthi kwakunento esandleni kulomuntu kodwa ke engenaso isiqinisekiso noma kwakuyisibhamu yini.
Yes, and I need to be very sincere with you. This is the evidence that the state is avoiding to touch base on, is afraid to deal with. But my question to you is, did you ever had dreadlocks?
Kodwa ke umbuzo kuwena ukuthi amarasta usuke waba nawo yini? No, my lord.
Dreadlock hairstyle, yes, dreadlock hairstyle, not simply dreadlocks, but dreadlock hairstyle.
Usuke waba nawo yini ama dreadlocks kuwena? No, I've never had hair on my head.
Lady and gents, I want you to take that all in and think about, what we're going to discuss after the break, because when we come back, we'll be getting into the description that was not only given by Thabang Makeleni, but as well as Zandi Kumalo and Tumelo Madlala, but also other elements that the state is using to say this was accused number 2 who allegedly entered the Kumalo home. More on this when we come back. Welcome back, and thank you for choosing to stay with us. Let's check in with our poll question. As you know, daily or every week, we have a question for you. And this week, we are asking you, now that Ntanzi has wrapped up or concluded his evidence in chief, do you believe he's set to collapse the state's case? 25% of you saying he is set to collapse the state's case. 63% of you saying he's worse off. And only 12% of you saying you're waiting for his witnesses. So keep voting as the show continues, because of course, at a later stage, we will of course be reflecting on those votes. But also, we asked you to comment on our social media platforms. On X, we are at Newzroom 405, but also on Facebook, we are Newzroom Africa. Let's check in with your comments on social media platform X. And this one says, the judge has already taken a decision. The state, including the judge, wants to see the end of this case. Those guys will be found guilty. The nudge believes everything Geninda says. So that is one of the social media users who, of course, is commenting on what we're asking you this week. But on Facebook, Nomahlukana says Ntanzi has multiple versions and no firm alibi, which is equals to the making of a hopeless defense case. So those are some of the views. We still have one more. We're still waiting for answers as to what was General Sibia doing in Phosphorus on the day that Senzo was killed. Advocate, therefore, is willing to give evidence, but no one wants to hear him out. We also have one more, I'm told. The state's case collapsed long ago. The hole they are in is just being dug deeper and deeper. They are 100 feet under now. So those are some of the comments that you have sent for us. But of course, we continue this conversation. You recall before the ad break, we played a clip from Advocate Mnisi's cross-examination in relation to a statement that was deposed by Thabang Makeledi, who has since passed away. This statement has been a big talking point in this case. And Thabang Makeledi, unfortunately, cannot come to court to detail what exactly he saw. And I want us to go to Kabelo Siabi. Kabelo, the issue around the description that was given by Thabang Makeledi, it's one of the other descriptions. And when you remember the evidence of Brigadier Bongani Ntanzi, he says he went back and looked at for example, Bongani Ntanzi's ID. He looked at the height that was given by Makeledi, as well as Bongani Ntanzi's height when they were measuring him for purposes of ballistics, and he was convinced. But there are also other issues that Advocate Mnisi is raising, like whether or not Bongani Ntanzi had a gold tooth and whether or not he had dreadlocks. And there's a case, in fact, that I'm reminded of that speaks about issues of description, the issue around whether there was enough lighting, and the circumstances really around the description of a person that could possibly be involved in a case. Are we looking at that case study here?
There are different factors. Firstly, the statement made by that witness who did not come to testify would be hearsay. You must remember the witness is not there to confirm under oath that what is written in the statement is correct. He cannot be challenged as to what he recorded in the statement, whether it was correctly recorded in the statement or not. Therefore, that evidence would be approached on that level, firstly. Two, you must remember that what Advocate Mnisi is saying is not evidence. Advocate Mnisi is not under oath. He can make statements to witnesses, but what is evaluated is what the witnesses give under oath. You do not evaluate the statements made by a legal practitioner who's not under oath and elevate it to being evidence. So it is not evidence that which Advocate Mnisi is saying. What is evidence is what the witness in the witness box says under oath. Now, the difficulty with identifications has always been recognized in our law. And when a court looks at identity evidence, it must first look and examine whether there was sufficient time to make a proper observation, whether there was light that would enable a person to make a proper observation, whether there are any special features or unique features in the identification that the witness is able to give. It has been found in many, many cases that one cannot simply rely on what a person gives as an identification. What is critical is to find material that would support a identification, independent material that would support that identification. And in this case, the state is relying on that to say that these identifications given by these witnesses might not be correct if they are looked at alone. But in a case, you do not look at the identification in isolation. It has to be looked at with all other surrounding material, which can strengthen that identification or weaken that identification.
All right. Now, investigators in the Senzo Meyiwa Murder Trial previously told the court that Bongani Ntanzi claimed he was at work on the day that footballer Senzo Meyiwa was killed. But that alibi allegedly failed when they followed up with the Human Resources Department at his workplace. And now, under cross-examination, he got to tell the court his version. Let's take a look.
On the 26th of October, that is the date when this incident was committed, where were you?
I said it here, my lord, even at the courtroom, that if I'm not on duty and then I am back home, Kwanongoma, if I'm not back home, my lord, or if I didn't go home and it's a weekend, then you will find me where the traditional dance would be.
Is it correct that on the 27th of October 2014, you took leave?
Yes, I requested, my lord, because I was tired. It tires to work in the mine.
That leave was going to commence on the 27th of October 2014. Until when? Do you remember?
I can't remember well, only if I can just see the form.
Instructed by accused number 4, Mr. Mapisa, and is going to come and testify that, as I have indicated to you, that he says that on the 26th of October 2014, he was not with you at the crime scene or at Masotweni Hostel.
Yes, I hear, because I was also not there.
All right, let's go back to my guest. Bongani, we're hearing again under cross-examination. You know, we've been talking about the issue of the alibi. We touched on this last week, and you said you were still cooking. It's coming, it's coming. Do you think it has landed?
I told you, and I'm still going to tell you, you know, they normally say the stove is on sticks, ne? Here, the maximum number is not going to be 6, it's going higher, and I'll tell you why. The questions around Ntanzi's identity, how was he looking like versus now, being asked as to, did you shave? Well, no, did you have beard at the time? No. Then Ntanzi says, go and get pictures of me in 2013. I did not have any beard. So it is impossible that I would have grown that in less than a year, such that look, the description that is being given is now fitting. Then you fast forward, you then can't help but remember that we've got a problem here. Constable Zungu once told us about a statement that he made, and he made things like, I know, you know what, he gave a version that he owns this whole thing, only to learn later that no, actually, he heard it from his father. His father, who alleged, he heard it from Bexen. So there's a problem here. where there's a problem of us relying on people who in themselves are not even telling us the truth. The very same constables who tell us the story that, no, I saw them there, and then they give us that description. My question is very simple. How do you even trust that when the very same constable Zungu now with images that the very same things he said was, he heard it from somebody else, and then we heard it from Geninda, by the way. It's Geninda who introduced, it is Brigadier Geninda who introduced Absalom Zungu to say, Ntanzi got these things from Absalom Zungu. So I'm simply saying the description as to how Ntanzi looked like, the beard and all the stuff, we're learning that no, Ntanzi did not have all of those stuff then. And so I'm not expecting anybody to tell me that, no, but Constable Zungu saw them, because the Constable Zungu we're talking about gave a version as if he owns the version, but now we learn, no, he had it from somebody else. So I'm saying, look at the witnesses that the defense is about to bring in defense of Ntanzi's case. You will ask me, Bombs, where are we? I will tell you we are cooking.
We're cooking. Sibongiseni, last week we discussed the issue of the alibi, and Bongani said, it's coming, and he seems to believe, the defense is still cooking. Ntanzi's evidence in chief has concluded. Has it landed? Is it clear to the court where Bongani Ntanzi was on the day that Senzo Meyiwa was killed? And if that would be easily corroborated by another witness who he may call? Yeah, Sibongiseni, go ahead.
Yes, hello. I don't know if you can hear me.
Yeah, we can hear you. You can go ahead.
Yeah, well, this one of an alibi, let's start here. Remember that the witnesses who then I think Ntanzi was supposed to refute whatever allegation that he was giving about him. Let's start about Zungu, right? Zungu says, hey, on this day I was with you at Basutwini Hostel. Let alone just to give the bad denial and say, no, I've never been at Basutwini Hostel. At that point, that is when Ntanzi was supposed to say, yes, I was not with you at Basutwini Hostel, as much as I don't even know that place. On that specific day, I remember very well, I was at home. Well, it was never put to the witness to comment on that issue, because this is your defense, which you are going to put until then you have an opportunity to testify and put it as evidence. You put this version and you take the stance, and then now you clarify, yes. You remember, even when Constable Zungu says he was with me, I refuted that because I know exactly that I was at home. But I don't know for what reason it was never put. And this thing of being at home now under cross-examination, because we must remember this is a cross-examination by Advocate Numalu. And at the time he was being led in examination in chief, I don't know for what reason he never explained into detail that the reason why I am saying I was not involved in the case and I was not at Mzamo section or as well as Basutwini Hostel is because I know exactly on this particular day that I was at home. He keeps on saying in examination in chief at the boardroom, I informed them that it's either I was at work or I was at home. That is not clear as to where he was at the time he was testifying in examination in chief. But however, under cross-examination now, he clarifies, and then because he has confined himself that he was at home. So, well, that is his alibi. And suppose it maybe somebody from his home state is going to come and confirm the alibi to be true, or in fact to collaborate his evidence and to make it strong. We can't just shy away on the fact that he has given an alibi, but which is in a form of a bad denial. That is the unfortunate part.
Yeah, and what are the consequences of this, Kabelo? Because, I was either at home or at work. And we know already the state said he gave us an alibi saying he was at work. And we went and it turned out to be false. So what are the consequences of that? Because he's playing an either or type of thing.
Thank you, Linda. Linda, the problem arises specifically from that aspect. He raised a defense of an alibi to say that I was at work. Now that there has been evidence produced that says he was not at work, he now gives a different version to say, if I was not at work, I was home. And even when he says he was at home, it is not very clear where at home he means. I tried to discern from what he was saying as to whether he was saying he was at his residence where he was living during his working life, or was he at home, meaning that he was in Nongoma. I wasn't sure. So it is not very certain now if he wants to bring a witness, what the witness must come and confirm. Whether the witness must confirm the version that has already been discarded, that he was at work, or this witness must now come to say he was at his residence in Gauteng or Nongoma. It's not very clear exactly what his defense is.
All right. Hang 10, I want us to take a quick ad break because when we come back, we'll be talking about another contentious element of this case. Bongani Ntanzi, the alleged intruder, is said to have entered the Khumalo home, tussled with the deceased. But one of the other issues that advocate Khumalo raises is the issue of the DNA. So I know that's a big talking point, even on social media platforms. So I want us to talk about that when we come back. Welcome back, and thank you for choosing to stay with us. You're still watching Inside the Courtroom, the Senzo Meyiwa Murder Trial, and I'm still joined by my panel of guests, Itu Mukwena, as well as Bongani Masuku, our commentators following the case, and of course commenting daily on the developments in that case. Kabelo Siabi, as well as Sibongiseni Kunene, our legal analysts who help us make sense of the legalities in the case. And like I indicated earlier on, I said we're going to talk about the DNA. And Itu, I know you're itching to talk about Alibi and the DNA. Let's go, 30 seconds.
Okay, when it comes to the alibi, you know what? I'm not even going to go there, because why are we only finding out when Ntanzi was during cross-examination? Ramsapila, how do you allow your colleagues to come and prove their case using your client? Let's go to the DNA. I think when it comes to the state, the DNA is quite clear. It's very neutral. It doesn't say that the people that lived in that house were in that house. The people that use crutches, my own crutches, don't have my DNA. Therefore, I am not surprised if none of the accused DNA is not on the head. For the state, I mean, the DNA is going to be a neutral point to argue. I don't see how the defense can use the DNA to sway their case or to favor their case in anyhow, Linda.
Yeah, Bongani, your issues with the DNA, I know the people that are on your side really love clinging on to this conversation about the DNA and how, the accused were not picked up. Therefore, there's no direct evidence that places them at the scene.
The issue of the DNA, it's like the case, if you remember the case, the state between the state versus Omotoso, the judge said, the judge released Omotoso because the state did not prove its case beyond reasonable doubt. Listen to this. I like this case. The judge says, neither you, Omotoso, can convince me that you are innocent. But on the basis that the state did not prove its case beyond reasonable doubt, I am releasing you. Omotoso is free as of us speaking today. The DNA test, you can't say, it's neutral. It's got to be conclusive or inconclusive. You stand there. There's nothing in this case that is neutral.
Yeah. Quickly, DNA and what we should look forward to going forward. The state will start cross-examination. What should we look out for going into the new week?
It should be just the comparison of the evidence of the trial within a trial, which Ntanzi tendered, as well as this one during their cross-examination. Well, I cannot comment much on the DNA because logic does not make sense. Why do you bring evidence that is not proving your case or otherwise? So even if you want to argue it, you can argue it on both sides. But unfortunately, then the accused person has to benefit, wherein the expert has said, according to scientific, we are saying you were not there. But it does not mean that the other evidence has to be discarded, which then implicate and put them on the crime scene. But insofar as the DNA, you can say it's negative on the side of the state.
Yeah, Kabelo, we've run out of time. 10 seconds. DNA and what we should look out for.
The DNA does not move the needle to the right or to the left, and therefore it is not going to persuade the judge to move to the right or to the left. The cross-examination will be intense in a sense that the state will then bring up all the previous inconsistencies that have arisen in the version of the accused, and in an effort to demonstrate that his version should be rejected.